meeting of the Athens Board of Zoning Appeals. The time is 8:10 and the date is May 8th, 2007. At this time, I'll call the meeting to order. The board consists of 5 members and 2 alternates. The alternates take full part in the discussions and become voting members in the absence of a member or when a member abstains for conflict of interest. Present tonight are members Mr. Gruzier, Mr. Lavelle, Mr. Gulsey, and Mr. Flores, who is an alternate and will take full part in this discussion tonight in the absence of our chair, Ms. Frederick. I am Betty Hollow, and also present are Zoning Administrator Steve Pearson, Acting Secretary Paul Eschenbacher, and Athens City Prosecutor Mike Miller. The board operates according to the following procedure. The chair will name and describe the case. The zoning administrator will state the basis of the objection and any applicable facts or conditions pertaining to the case. The appellant or their representative will give reason why the appeal should be viewed favorably. Anyone wishing to speak in favor of the request will be heard. Anyone wishing to speak in general comment will be heard. Anyone wishing to speak in opposition will be heard. If necessary, the appellant or their representative will offer concluding summary or rebuttal remarks. Testimony from the floor shall be closed. The board will deliberate and render a decision. According to Athens City Code Section 230703B, the board has the power to grant variances from the strict application of the code, provided the variance will not be contrary to the public interest, the spirit of the code is observed, and public safety and welfare are secured, and substantial justice is done. According to Athens City Code Section 230910C, variances from the code shall not be granted unless the board finds, based on direct, specific findings of fact, that each of the following conditions has been supported. 1, practical difficulty and undue hardship. Because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property, a literal enforcement of these regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes. Exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes of uses in the same zone. Preservation of equal property rights. Literal interpretation of these regulations would deprive the appellant of rights commonly enjoyed by others in the same zone and the same vicinity, while a granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone and the same vicinity. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property. Absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest. Not of a general nature. The condition or situation of the specific piece of property or the intended use of said property for which the variance is sought, one or the other or in combination, is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such condition or situation. The board also has the power to review decisions of the zoning administrator when an error is alleged, hear requests for conditionally permitted uses, hear requests for substitution of non-conforming uses, determine the number of required off-street parking spaces if the specific use is not contained in Section 2311 Table B, hear requests for temporary use of structures or premises, consider requests for extension of temporary permits after receiving a recommendation from the Athens City Planning Commission, hearing requests for business use variances after receiving a recommendation from the Athens City Planning Commission, and hearing requests for variance from the strict application of the Athens City Code Title 25, Flood Damage Prevention. Any person, resident, or officer, department, or appointed body of the City of Athens aggrieved by a decision of the board may petition the Athens County Court of Common Pleas concerning the illegality of the decision. Such petition must be filed within 30 days after the mailing of the decision of the board to the applicant. There are only 2 cases on tonight's agenda. The first case is number 0708V. It's 41 Sunnyside. The zone is R1. The applicant is James Etchison. And the second case is 0709V, 27 Brown Avenue. Again, the zone is R1, and the appellant is Richard Lockwood. The board is required to take testimony under oath. So anyone wishing to speak concerning any item on the agenda should stand and swear or affirm that any testimony they present to the board will be the truth, the whole truth, and nothing but the truth. So if you want to speak, will you stand and so affirm?
I will do.
Thank you. So we're ready for the first case. So, Mr. Pearson, perhaps you would tell us a bit about 43 Sunnyside Drive.
My name is Steve Pearson. I'm the zoning administrator for the City of Athens, Ohio. Case number 1 tonight has to do with 43 Sunnyside on the Near East side of town. The request is for 33.4% lot coverage where 30% is the maximum permitted. Officers on investigation noted that Mr. Etchison, the appellant, had started to construct a deck on the side of his house. Actually, it's kind of like a large stoop off of a doorway. And he was asked to apply for a permit to do such. And when we calculated out the lot coverage, that's when we found out it was excessive. It was 3.4% over the 30. All the lots in that area are 50 to 55 feet wide. This particular lot has a lot, excuse me, a lot area of 5,500 square feet. In newer subdivisions now, the minimum lot size is 8,000 square feet. But the lot coverage is based on the size of the lot, as opposed to a certain X amount. But just for example, 30% of an 8,000 square foot lot would be 2,400 square feet. Mr. Etchison is asking for coverage of 1,838 square feet. So it's way below what would be permitted on an 8,000 square foot lot. It's just that the lot's too small. There are no other problems. The deck will be over 8 feet away from the adjacent property line to the east. There's also a fence under construction, which fences are not regulated by the zoning code unless they're over 6 feet tall or in the front. And the fence that's being constructed there is neither, so no permits needed for the fence. In case you weren't able to get by to look at it, I went over and took 2 photos today. There's one, there's the other from a little closer. First one, I tried to back up a little bit from the street, and the fence is right on the property line on the east side, so you can see the distance between the deck and the fence right next door. And then the other picture is just the one that's a little more of a close-up. Probably the best illustration is probably the one that's a little further back, where you can see the fence, the deck, and the side of the house.
See the fence there, too.
And I guess besides that, unless you have any questions, I don't really have anything else.
Any questions, anybody?
No.
Nope.
Thank you.
You're welcome.
Mr. Etchison, would you like to speak? And would you please state your name and address for the board?
My name is Jim Etchison, and the property is 43 Sunnyside. I'm looking for a variance of the 30% lot coverage. The property is single-family, owner-occupied. It was built in 1901. It is over 100 years old, obviously. The house, as it sits right now, is 2,340 square feet, plus the garage. And as it sits, without putting the deck on, it already exceeds the 30%. It's 31.1% of the lot as it currently exists, of the 50, as Steve stated, of the 5,500 square foot lot. The variance that I'm asking for is an 8 by 16 foot deck, which is 2.3% of the lot, which would equal the 133 and a fraction. But the real reason that I'm looking for a variance is the house has no access to the backyard. to get to the backyard as currently exists, one has to go out the front door, go around and all the way around the house, or go out the side door through a garage, which is 2 doors, or go around the garage, which requires going into the neighbor's yard. You know, I've looked at this, and the deck provides a transition into the backyard. You know, I plan on having small children, grandchildren in the backyard, and by having this deck, it provides some access. The property falls back about 3.5 feet from the front to the back. So you can't just have a door coming out and down with steps. It's rather excessive. I've scaled back the deck. Originally, I planned on a bigger deck getting to the backyard. The property, at some point in time, probably in the 20s, looking at the construction technique, had an addition on the backyard, or on the back of the house, which prohibits having a rear, you know, standard back door. It probably had one at some point, but that's long gone. And one of the things we looked at was, could we take one of those rooms, it's 2 bedrooms and a bathroom with a hallway, but you know, there's bearing walls and that sort of thing. So at the end of the day, I arrived at the deck, which would allow access to the backyard. And it's really, it's a safety issue. It's just a livability issue. As it currently exists, the backyard is only 50% really serviceable as we would, you know, believe a backyard would be. So that said, I would ask that the committee grant the variance. I believe it is in accordance with the general purpose and intent of the code, that it would not be injurious to the public welfare. It does not impair air or light supplies. It does not impact congestion, increase fire risk, endanger public safety. And, you know, in fact, for the people living there, it actually increases public safety and does not represent special privilege. Looking at all the houses on Sunnyside and the adjacent streets, all houses have access to the backyard. They all have back doors. So this is just a aberration, I guess, as far as building in Athens. And about starting ahead of time, I'm new to the community. We did, you know, check out where what the deal was as far as the fence, and I thought we were on okay as far as the deck, only the 30%. So I'm a little smarter now than I was 4 months ago. So that's all I have to say. I would appreciate if you would grant the variance.
Let's see if anybody has a question for you. Apparently not.
Right. Thank you.
Thank you. Mr. Pearson, do you have anything you wanted to add?
One thing I didn't mention was that the code allows for necessary stoops and landings, essentially without a permit or not considered as part of lot coverage. It's just kind of a judgment call. Do you need a 3x3 landing to get out of the door and a set of steps down, or 4x4? When does it actually not really necessary to be that size? So it's more, I think, toward that intent, you know, to be able to, the house sits up, if you noticed, quite a bit higher than the lot. And as it drops off in the back, the floors must be level all the way through, and so the drop from the distance from grade to where a back door would be, or any door really other than the front's very high. So I just wanted to mention that too. If it could have been considered just necessary, that would have been all right even without a permit.
Okay, thank you. Is there anybody who wishes to speak in favor of this variance? Anyone who wishes to speak in general comment? Anyone wishing to speak against this variance? Okay, in that case, we will close the discussion from the floor, and we'll discuss it ourselves. And so, is there someone who would like to make a motion?
Before we make the motion, since you were not here last time,
Okay.
Mr. Miller instructed us that if we find any of the 6, any one of us finds any one of those 6 criteria does not meet, we must vote against the variance.
If any one of us finds?
If any one of us finds in our own judgment, we have to meet every 6 criteria. I
You're
mean,
not
I have
saying
to
that
meet- no,
all of us,
no,
you would have to.
each one individually.
Yes,
yeah.
that's what I've understood,
yeah,
so I'm
yeah,
glad
yeah.
that you would
Yeah.
reiterate that for
So
the,
that, yeah.
for the audience and for us as well. Thank you.
Mm-hmm.
So, have we got a motion?
I move we grant a variance in case number 0708V, Zone R1, 43 Sunnyside Drive. James Etchison, appellant. The applicant is requesting a variance from section 23.11, Table A, Schedule of Bulk Controls, to permit addition of a deck to an existing structure where such addition would create lot coverage of 33.4%, and 30% is the permitted maximum.
A second.
Good, thank you. Anything you want to discuss, or do you want to go straight to the findings?
I just need a point from Steve.
Okay.
If he didn't tie this into the house, he would not have to ask permission from this board, right?
No, that's not correct.
What would
It would
be,
be an
If
accessory
it was
structure
smaller.
then.
okay.
But then he wouldn't be
Zoning
able to
is
get out of the
based on
house.
The term structure, the definition is something that's attached to the ground or attached to something that's attached to
Okay,
the ground.
got it.
So even if, like these awnings on Fort Street, even though they're not attached to the ground, they're still a structure because they're attached to the building. So in either case, it would either be an accessory structure or part of the principal structure.
Okay, thank you.
Anything else? Okay. The first finding pertains to the practical difficulty and undue hardship because of exceptional or extraordinary circumstances or conditions pertaining to this specific property. A literal enforcement of these regulations will result in practical difficulty or hardship that is unnecessary to achieve public purposes. So if we interpret the code quite literally, would it create a severe difficulty or undue hardship for Mr. Etchison?
I think it's an undue hardship as a property owner not to have access at the back of a section of your house to a major portion of your yard.
Anything you want to add to that? Okay. Exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property or to its intended use that do not apply generally to other properties or classes or uses in the same zone.
Size of the lot is small.
Well, I don't think you can say that that's an exceptional circumstance here because this is an old neighborhood, so the lots are probably of similar size. But it may be exceptional for the other houses not to have back doors. And for this one to have had an addition that somehow precluded a back door and that now they no longer have access to the backyard except by strange maneuvering.
Again, we are applying the same rule to the 8,000 square feet lots to this smaller one, which is only 5,500. So
Well, but if you look, but if we are only considering, yes, I
Yeah.
agree with you, but we also are looking at, is there something exceptional about this property in this zone, in this vicinity?
Yeah.
And so you can't say that it is a small lot,
Yeah,
but
it
they're
is.
all small.
They're all small, yeah.
So it's a small lot, and he can't get to the backyard without
Yeah.
some way to get there. Literally, this is preservation of equal property rights. Literal interpretation of the regulations would deprive the appellant of rights commonly enjoyed by others in the same zone in the same vicinity, while the granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone or the same vicinity. So is this going to give him some special right?
No,
No,
he'll have access like his neighbors do to the backyard.
Okay. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property.
I would
think
say yes.
8 by 16 is fairly reasonable, very small, and otherwise there would be no need for using a deck. So
Well, and in fact, it's so narrow that it's
Yeah.
probably not going to function that much as a deck to
Yeah.
begin with, but rather a transition structure. Absence of detriment. The authorizing of such variance will not be of substantial detriment to property, to adjacent property, and will not materially impair the purpose of the zoning code or the public interest.
no,
Any
actually,
detriment here?
again, no.
No.
No, I don't think that it's going to bother anybody. It's not too large, and there's a fence that protects it anyway. Not of a general nature, the condition or situation of the specific piece of property or the intended use of said property for which the variance is sought is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such a condition or situation.
No, it's not
No.
general.
Okay, no. So you ready to vote?
We are.
Shall we start with Mr. Flores?
Yes.
Yes.
Mr. Grizzle?
Yes.
Yes.
And I also vote yes, so you have the variance, and you can speak to the code office about what you need to do now. Thank you. Let's go to the second case. This is case 0709B, 27 Brown Avenue, and the appellant is Richard Lockwood. So, Mr. Pearson.
Again, just for the record, my name's Steve Pearson. I'm the zoning administrator for the city of Athens. As you mentioned, this is also a property located in R1 single-family residential zone. Currently, 27 Brown has no parking. It's all parking on the street. And Mr. Lockwood would like to install some parking, put in a driveway, and park in the backyard. The problem is, though, the code requires 10 feet of width at a minimum for a driveway, and the distance now from the house as it exists, and again, it's a turn-of-the-century house, from the edge of the house to the property line is 9.9 feet, 9 feet 9 inches, 3 inches short of the requirement. Something else that you can't read in the zoning code, but it is in the landscape ordinances, there's a 4-foot landscape buffer that's also required. So really, the minimum distance you have to have from your house, let's say, to the property line is 14 feet. 10 for the driveway, 4 for the landscape buffer. I've already presented this proposal to the Tree Commission because they have to grant approval for a consolidation of landscaping. And they reviewed it, looked at it favorably, and said that they really didn't have a problem with it. Here's a picture of the distance from the house to the property line, which is basically on the edge of the car. And then here's the backyard where the parking will be. There's a deck on the back of the house, and the parking will be back here, so the Tree Commission was satisfied with all of these trees.
How much parking will he be able to provide?
The proposal is for 3 parking spaces, I believe. They all have to meet the size requirements. In an R1 zone, you can stack park. Stacking's permitted, so really, if you just put a long driveway in all the way back and didn't even expand it out to an area a little more open, you could get 3 cars
Okay.
fairly easily. But again, there's just not enough room there because of the actual location of the house. The lot is 43 feet wide. It's not very wide. There was 6 feet taken off at one time and transferred to an adjoining property. So it wasn't very wide to begin with and got even narrower somewhere along the way. Brown Avenue, if you've driven on it, it's a one-way street. It's very tight. There's parking permitted on one side because there are quite a few places that don't have parking. And so parking is permitted on the street. That's probably why it was changed to a one-way street. And Mr. Lockwood's just trying to get some parking to make living in the house a little more attractive. We actually can have a place to park and not have to worry about 24-hour parking enforcement.
Does he live there, or is this a rental?
It's currently owner-occupied.
Because
Or
the
family
address that
owner-
we have here is
Family
Kingston,
occupied.
Ohio. It's
Right.
family occupied.
Right. So, no, there's no rental permit on it currently. And we're seeing quite a few, just to be real upfront with you, we see a lot of parents now who are coming to town. They see how much rent is, and then they decide to buy a house and have their children live in it while they're going to school, and then sell it afterwards.
And if they put that driveway in, will that limit the street parking because they'll need to have an area to swing into since that's such a narrow street? I'm assuming that if there were vehicles crowding that driveway, it would be pretty hard to make that turn? Or
There'll
how do you-
be one parking space lost off the street
Okay.
in order to put the driveway in, and the proposal is to park at least 3 cars, so you have a net gain of 2 vehicles. And when the service safety director is looking at opening permits, say it's something that doesn't have to go to the tree commission for review or to the zoning board for review. That's the main criteria we look at. You at least want to balance, and hopefully you have an increase in parking anytime you take space off the street. So there's a net gain of 2.
And it
at
doesn't
least.
have anything to do with the occupants or the occupancy of the building?
Does
Is it
does
going
parking have to do
enhance
with-
how many people could live in that facility?
well,
It's an R1
yeah.
district. so
In
that's
order to
self-limited.
convert, there's a new, fairly new regulation. If someone wants to convert a property to rental purposes, they have to have a minimum of 2 parking spaces on the lot, a minimum of 1 for each permitted occupant. In an R1 zone, the maximum number of residents unrelated to each other is 3. A family could be any size.
Right, yeah, we've been through that a lot.
Yep. So you have to have, say, if you had 2 parking spots, you get to have 2, you can have 2 tenants and not 3. So occupancy is driven by parking.
So we'll be creating 3 parking spots.
At least
Even
3.
if they stack.
Right. So even if you could stack 5 cars in there, that doesn't mean you can have 5
So that would
people.
increase the occupancy rate of the house, is that correct?
No,
Not
You
necessarily.
can't stack.
If it was a rental?
because it's an R1 district, you're limited to 3 unrelated people,
Yeah,
presumably,
that's the maximum they could ever have in there as a rental is 3, but they could have
legally.
15 people.
That's
So
all.
if you've got 3 unrelated, you'd need 3 parking spaces.
That's correct.
So
But
in
a
order
fa-
to convert it to a rental and have 3 people in there, you'd have to have 3 parking spaces, is that correct?
That's correct.
Now I'm getting to what I'm trying to find out.
You can, you could, Mr. Lockwood, if you could find a family that wanted to buy it
Right,
and move
yeah.
in.
10 of them can park.
Right. You might have more cars and there wouldn't be any review for parking.
Right.
But he's not here requesting that. He's requesting a variance for the
For the
driveway
driveway,
width.
that's what we.
Yeah, not for the conversion to rental
Right.
related to parking.
Okay. Other comments from Mr. Pearson from you all? Thank you.
You're welcome.
Mr. Lockwood?
No, I don't think he's sworn in. He didn't swear in.
Were you sworn in? No?
No.
Okay.
I realize I was,
Okay. Do you swear to tell the truth and nothing but the truth?
yes, I do.
Thank you. Okay. Tell us your name and address.
My name is Richard Lockwood, and I'm the person requesting this variance for 27 Brown Avenue. And I believe that Mr. Pearson explained well the reason that we're requesting the variance, that we have only on-street parking, and with a 24-hour parking limit, it's very unpractical to live in and use the home as it is. As he said, the reasons that we request the variance are that a driveway is needed. We want more than a driveway. We want parking in the back of the house that would allow room for 3 vehicles. And to reach that area, our lot actually it goes back to Miller Avenue, but there's a steep hill and it's impractical to use that for parking. And to gain access to that, we need a driveway to get back. We have 9 feet, 9 inches. We did have a survey performed, so we know that we need that much. And city code requires 10 feet. There's a the adjoining land has a driveway, and it perhaps showed up in the photograph that you saw.
Then gravel.
It appears to be a limestone driveway. It's not a conventional paved one, is that correct?
Right, it's, I think, a gravel type of. The circumstances in the variant, or in the code do not, the circumstances of the variance do not apply in general to other properties in the zone. As I believe Mr. Pearson said, most R1 lots have enough room to put in a driveway. My house was built around the turn of the century, or before the automobile was in use to the extent it is today, and before the code was put in place. And As he also mentioned, apparently somewhere along the line, it was before we got access to the property, some of the land was sold off, that we wouldn't be able to do that. And denial of the variance would deprive me of reasonable use because I would not be able to have access to off-street parking. Strict application of the code would create hardship for me because it would prevent me from obtaining access to off-street parking. And it's difficult to do without off-street parking, as I said, because city ordinance requires that a car parked on Brown Avenue must be moved every 24 hours or be subject to a fine. And from this ordinance, it seems apparent that the city does not want anyone to park on Brown Avenue for any extended time, that is specifically more than 24 hours. Another hardship would be exposure of my vehicle to damage from other vehicles on Brown Avenue. At one time, when I was parked on Brown Avenue, another vehicle, or my car was damaged when another vehicle ran into my car and then left and without notifying me. The variance requested would be the minimum that would allow me to obtain access to the parking as requested. It would not impair on air or light of adjacent properties. The variance will not substantially increase the congestion in public streets. Rather, it would decrease congestion on Brown Avenue by getting my vehicle or vehicles off the street and into my own parking space on my own property. The variance, furthermore, would not increase the risk of fire or endanger public safety or substantially diminish or impair adjacent property values. In fact, the decreased congestion on Brown Avenue provided by the variance as described would favorably, or should favorably, impact the ability of firefighting vehicles and equipment on the street in the event of any fires in the neighborhood, and should also favorably impact the ability of emergency vehicles and police vehicles to be parked on the street when needed, and thus favorably impact the public safety in the neighborhood. I believe the variance will not confer any special privileges to me that would otherwise be denied to the other owners of land and or buildings in the same zone. It appears to me that most of the other properties located on Brown Avenue already have their own off-street parking. So unless there are any other questions, I would like to thank you very much for your consideration of this request for variance.
Any questions?
No.
Thank you very much.
Thank you.
Okay. Mr. Pearson, did you feel the need to add anything?
Just one thing real quick that Mr. Lockwood did mention, and I did before. All the houses on Brown Avenue on the south side, their lots go all the way through to Miller, which is kind of clear up on the ridge behind Arts West. And it's a very steep hill, wooded, so it's rough to put any parking, and then you'd have to walk down the hill to get to the house. Everything, if you've been down there on Brown, everything down there is tight. You can tell that it was a subdivision that was platted
A long time ago.
long time ago, and
Right.
it makes it very difficult, especially in a rural neighborhood like this, to meet some requirements that are based on lots that weren't even
Right.
imagined.
That are only 43 feet wide, yes.
Yeah, it's very narrow. It's probably lucky that it's only 3 inches shy.
Thank you.
So, and I just want you to know, too, the tree commission, I'll just say that again. I took it to the tree commission. They said they were fine without the landscape buffer along the driveway.
Okay,
The whole
Thank you.
backyard's of woods, essentially.
exactly. Is anybody who wishes to speak in favor of the variance? In general comment? Anyone who wishes to speak against the variance? In that case, we will close the discussion from the floor, and we will discuss it ourselves or move to the findings, which I take it is what you'd like to do. Let's get a motion.
I make a motion that we approve variance in case 07-09V, Zone R1, 27 Brown Avenue, Richard Lockwood appellant. The appellant is requesting a variance from section 23.10.01A to permit driveway with a width of 9 feet 9 inches where 10 feet is the permitted minimum, plus a 4-foot landscape buffer.
Okay,
Second.
thank you. Okay, let's look at the findings. The first one is practical difficulty and undue hardship. Is there any undue hardship or difficulty that's going to accrue to Mr. Lockwood that is not necessary to achieve public purposes?
He rightfully wants a driveway and he wants a parking space, so I guess that's a hardship.
Okay, a it certainly would be a hardship, and I think the extraordinary circumstances here, which we can just combine with the next thing, really, this really is an exceptionally narrow lot, I think, and we're only talking about 3 inches here,
Right.
aren't we?
That
Okay.
would be minimum.
Right, so again, the exceptional circumstances are the size of the lot, I think, and the tiny amount that he's talking about. Preservation of equal property rights. Literal interpretation would deprive the appellant of rights commonly enjoyed by others, while granting the variance will not convey any special privilege. What do you think?
No, other people have driveways there.
Okay.
I think
That is-
anybody who wants a driveway should be able to get a
Yes, I
variance.
think in this town, if you can make a parking place, do it, okay? The variance granted is the minimum required to make possible the reasonable use of the property.
We just suggested that
3
it was
inches.
due to the 3 inches.
Right, we're talking about 3 inches here, okay. Absence of detriment, it will not be of substantial detriment to adjacent property and will not materially impair the purpose of the code.
No.
It will actually improve the,
Yes, I think you're probably right, it will be an improvement. It's not of a general nature that we need to ask the city council to form a new law to deal with it, okay. Shall we vote? Starting with Mr. Flores,
Yes.
yes.
Mr. Gerger,
Yes.
Yes.
and I also vote yes, so you have variance. Okay. I think we have some small business to attend to. I wasn't here at the last meeting, so I'm not sure what the correspondence is about. Mr. Pearson.
What I provided each of you with is a letter to address to the Board of Zoning Appeals from the Executive Committee of the Southside Community Association of Athens. In the letter, they'd requested that the Board of Zoning Appeals review the approval for a use permit of the Summit at Coates Run. There are, though, some applicable court cases, in particular, an Ohio Supreme Court case, which I noted in the letter of response, which is the second page. There's a Supreme Court case, it's called Walco Trucking versus Talmadge Board of Zoning Appeals. Talmadge is the county seat of Lake County in northeastern Ohio. And there was an adjacent property owner that was aggrieved by a decision, an administrative decision to grant expansion of this trucking firm. They went to the Board of Zoning Appeals. The board overturned the decision of the administration. It went through the court process and finally did make it to the Ohio Supreme Court. The Supreme Court reversed the trial court's decision, and they said that the Board of Zoning Appeals could only hear cases where someone had been refused, that there was a different process to use to appeal an approval. So the letter is just a copy of the letter that they sent to you. The second page is my response letter. And you may have already seen this talked about in the newspaper, but I did want you to have a copy of the letter that they sent you and the administrative response.
Okay, so basically, we don't have a voice in this, and we're just
No.
being apprised of the situation.
Right. Just so you know, the zoning code actually says anyone aggrieved by a decision of the zoning administrator, and then it says approval or refusal can appeal to the board, but essentially this court case nullifies that one section. The judge, Judge Moyer, wrote the majority opinion, and he said that he believed that the state legislature must have meant for a different procedure to be used by someone who was aggrieved by an approval. That
So-
zoning boards would not hear that case.
Okay, and then, so they have some recourse in the face of,
Right. They can request an injunction. I don't know for sure, but I believe that's done through the Court of Common Pleas.
okay. But it
So that
doesn't
is,
include
yeah, there's
us.
still administrative, there's still relief available.
Okay. All right.
If not, anybody who didn't like a permit that was approved could come in and appeal it to the board. So you'd probably hear quite a few people who
Right.
wondered why a permit was granted. And this is why you don't hear those.
Okay. Thank you.
You're welcome.
What about the minutes from March 3? Who has,
Looks good.
13, make a motion to accept the minutes of March 13, 2007.
okay, do I have a second?
I second.
Okay. Any other thing you want to address?
He mentioned something about meeting on 25th for the training, Friday.
Friday the 25th to have a training meeting for zoning members. And I believe Mr. Pearson asked us to notify him if there was a time on that day that we could meet. So I guess I'm going to have to ask each of you to apprise him of.
Mr. Flores said he couldn't make that on
He said he would check.
Thursday or Friday.
and see. Did you say you would check and see?
I'll check and see, but Thursday and Fridays, got my clients that come in, all right.
Well, I wonder why they set it for a day when you couldn't come.
I don't know.
Did you tell them you couldn't come?
Yeah, I probably did, I don't know.
Okay, okay. So, will you speak to Mr. Pearson and then?
And notify
okay.
Mr. Pearson,
In the
yes.
meantime, the rest of us can let them know if there is a time that day when we can come. I can come anytime that day.
I could only come after maybe 3 or 4, so.
Okay, so late afternoon, anytime.
Late afternoon.
Late afternoon, Mr. Gruzer?
Sure.
What?
Anytime.
Anytime.
Anytime? Okay, so it's up to you. Okay, so you all can work that out
Put that
and let
pressure
us
on me
know.
publicly.
Okay,
Do you know how long this is going to take,
Well,
approximately?
Can we,
Oh, okay.
okay.
I know that Gary has a presentation for it, but I don't know how long.
make a motion to adjourn the meeting?
Yes, I think we should be adjourned.
I
Thank you.
second.
I think you're going to make it.
Hey, you people forget I work for a living.
Well, some of us used to. We don't recommend it.